evening, viewers. It is good to have you back tonight. 38 people have lost their lives. Over 200 have been injured in the violence that unfolded in northeast Delhi earlier this week. Now, as residents of the destruction-hit areas look to pick up the pieces of their riot-torn lives, there are also a few pleas regarding the developments in the run-up to the clashes and during the clashes that have reached the courts. For example, there is a plea seeking filing of FIR against hate speeches that have been made by a few BJP leaders this month, including the one by Kapil Mishra, just as tension had begun to build up in northeast Delhi. But the Delhi High Court, viewers, today adjourned the case, giving the police and the centre 4 weeks. Now, while during the hearing of this case, we told you yesterday what happened and some very, very stringent observations that were made by the justice who was hearing the case yesterday. Today, the court said, take a conscious decision on registration of filing an FIR. While the Solicitor General told the court that the situation is not conducive for registration of FIR right now, that we need more time to take appropriate action. This is Solicitor General Tushar Mehta speaking on behalf of the police as well, saying that the police is going through the videos, but right now is not the time to take any action. Right now is not the time to file FIRs. The hearing has now been adjourned for a week. This development comes in the background of what Congress party, in fact, Dr. Abhishek Singhvi, who will be joining me just a minute from now, wrote about, where he said that our court system is not in good health. He spoke about larger issues, about the infrastructure of our trial courts being inadequate. And then he dwelled a little bit about adjournments and how adjournments can make or destroy a case, and that there is a tendency to decide hard questions by adjourning cases. So let me, in fact, just go across to him first and say good evening to Dr. Singhvi. Dr. Singhvi, what you wrote, and what we all read in the paper today is, quite timely, considering what we saw even in the court today. Now, if I can ask you to elaborate a little bit more on that comment that you made about how hard questions and decisions are being made via adjournments. If you can elaborate on that.
Let me make one thing clear, and I'm glad you are giving me this opportunity. It was a pure coincidence because what you saw today in the Times of India was an article really excerpted from my forthcoming book, which I have in my hand now, From the Trenches, which is virtually released this week and will be released formally next month. But to cut a long story short, I have addressed several issues in that article, which have been kind of serialized in the Times of India. One is the scourge of delays, the beating the backlog. The second is, I think, and I hate to say it, but I think a declining level of scholarship in the court. The third is not addressing the hard issues and maybe subconsciously or consciously avoiding them. Adjournment is one method. And I certainly am not speaking about today's hearing. I'm certainly not speaking about a particular hearing because this is obviously written earlier. It is published. And fourthly, taking up issues in PIL which sometimes leave the persons concerned remediless. These are 4 out of many other issues which I've discussed in a particular article in the book, From the Trenches. But on the first part, I would like to say that, a court has to take a binary call sometimes. It's a black and white call. Now, life is grey. Life is not black and white. There are huge shades of grey. But the court, unfortunately, has got the headache to take that call. And they should take that call ultimately, otherwise not take up the matter at all. If a matter is taken up by a court, it must be pushed to its shortest logical black and white binary conclusion, rather than kind of discussing it in open court on a platform, having it reported, having it misreported, having it understood, having it misunderstood, and let the Ganges flowing by under it. Now, I am not speaking about any particular case. I am not speaking about any particular decision or bench. I am speaking institutionally. Either don't take it up or take it to a conclusion and take it to a conclusion as shortest possible time. It's no point sermonizing about something after the event is over, when your writ is fruitless, when the impact is zero.
I just want to also read out for our viewers, an excerpt which obviously has now come in the papers today and will be in your book. The Supreme Court in the past few years in matters where there are great stakes involved has shown a reluctance to act against the government. In another part, you write, when a court says that it will not hear the matter for the next 3 weeks, there is always the potential for the forest to be absolutely destroyed before the court even adjudicates the question. Where the clock is ticking against a party, the court should be conscious and alert to the fact that those questions must be absolutely decided immediately. Mr. Singhvi, now I am going to link the two and ask you if you believe this is also applicable to the case that was up in front of the court today regarding filing of FIRs in certain hate speech cases.
Well, I think it's unfair. It's unfair to link an article ex post facto on events which have occurred subsequent, because these were not present to my mind when I wrote it.
Absolutely.
So that part can be left out. The point remains, I made an institutional point, I made a long-term point, I made a structural point, I made a reform point. I am standing by my point, but I think it's not right to link it. But however, I try never to avoid questions. You are asking about today's event. I can say very frankly that it doesn't matter which side the court decides. Let's get that clear. I'm not speaking of the merits. I'm not even speaking of the politics of it. But it is important that the court decides.
Correct.
And now I'm speaking about today's event. Now, if the court is to give some relief of any kind, then it has to take a binary decision. I'm saying it with the consciousness that it's not easy to take black and white decisions because life is grey. But then the court has to say, look, would the registration of FIRs serve the purpose, send a message, be a deterrent, and will it control, subdue, reduce, etc. this issue? In which case, it's better to do it today rather than tomorrow. It's better to do it today and tomorrow rather than 1 week later. Or it has to take a decision that, look, we don't think that the situation calls for registration of FIRs. We think that the police is well equipped to deal with it. They need more investigation. Prima facie, there is no offense. Now, I'm giving examples. Now, we are talking institutional. We're not talking politics at the moment. Now, institutionally, doing neither doesn't serve the purpose.
Let me ask you a larger question. Do you also believe that when such repeated adjournments take place and a long period of time is, put in, that also adds to the burden and pendency of cases?
Obviously, certainly, absolutely. Repeated adjournments obviously keep the pot boiling. They may make for good headlines, they may make for good reportage, but just imagine, each time I adjourn a case, my next date will be filled up not with 50, but with 75 cases because I've adjourned 25 from the last time. It's much better to take up just 25 and dispose them off rather than to keep giving dates. Now, I understand not all cases are disposable on 1 or 2 dates, but you have to be focused on that binary decision making. Otherwise, don't allow it to be taken up easily. A PIL does not have to be taken up in every case. Where you are taking it up, the obvious object has to be to do palliative, immediate, remedial measures. Otherwise, why take it up? I've also mentioned in part of the book that there is a tendency with bona fides, I'm not talking of malafides, I'm not talking of motivational, but the climate is such, and it's quite obvious, and we are linking it now to current events for which this article was not written, but yes, events earlier have happened. The government, in some sense or the other, along with some wrong decisions of the collegium, has been able to send a message. You should be careful, you should be within line, you can be transferred, you can be, your elevation can be delayed at least, your promotion to the Supreme Court be heavily delayed, and time matters all in this because you have 1 or 2 years and a 6-month delay can be fatal. Well, this message appears to have gone home so that when push comes to shove, see 95% or 90% of cases are simple, binary, bilateral, private disputes
Right.
or government and private disputes which don't have a push comes to shove element. But when push comes to shove element is there, when the stakes are heavy, when the fiber is to be very strong, then if you have this climate of fear and intimidation and self-doubt and a climate of suspicion and a climate of a certain amount of vendetta, then obviously people take the easy way out. So would you if you were a judge. You have a family, you have a house, you have a life. Why should you get into it? Not that you're agreeing or disagreeing with me, but you just take the easy way out.
Okay.
That is happening in another class of cases, which I've addressed in this case,
Well,
in this book, sorry.
I would for sure look forward to reading it. Because you raised the issue of also transfers, Mr. Singhvi, is it fair to raise a controversy over the transfer of the Delhi High Court judge to the Punjab and Haryana High Court when the collegium itself had already recommended so 2 weeks ago? The timing just matched with this.
I, I have I have openly tweeted about it today. I made 5 tweets. If you read them, you'll get your answer. Point number 1, I am critical of the collegium in my first tweet. Just a few months ago, a different collegium, it is well known, did not allow a similar proposal to transfer the same judge to fructify. How does it change in a few months? Simple question. 2, I have said that since the incumbent Chief Justice in the other High Court has many years to go, so long as the incumbent Chief Justice remains there, and he has every right to remain there, this transferee judge is not being promoted. The Delhi transferee judge is being continued to be made number 2 there. Number 3, that Chief Justice cannot be guaranteed or cannot ask for and cannot be assumed to be shortly promoted to the Supreme Court. If that was the intention, he should first have been promoted and then this judge, Muralidhar Justice, should have been transferred there. Fourthly, I think anybody who knows the bar, who practices in the bar, knows that this gentleman is one of the finest, open, bold, erudite, hardworking, straightforward, simple judge. I don't think any camp, irrespective of ideology, irrespective of agreeing with him or not, has any doubt about that. So what is the message you are sending? And then last but not the least is a point about the executive. There are points about the collegium, but there is a point about the executive. Have you ever heard, I've asked in my tweet, any judge who is under transfer to be told by a notification yesterday, bang in the middle of the case he's hearing, this is a notification by the government, that he shall assume, directed to assume charge in the place of his transfer. Exact words, quote unquote, directed to assume charge.
Right, Mr. Singhvi, thank
Now,
you so
I'd
much.
like to see how many High Court transfers have been made like this.
I get the point
And
that
I
you're
say
making.
lastly that you, the collegium, have become the protectors. You, the collegium, have become the protectors of appointment and transfer. Well, you have to protect your flock. You are the protectors. You have taken that power. You jolly well have to discharge that duty. Power comes with the duty. Responsibility and power comes with accountability.
I take the point that you're making, Mr. Singhvi. Always a pleasure to have you with us. Thank you so much for joining us tonight and making those very interesting points on both of the two big stories that we've been tracking, and in a larger point about how perhaps the courts are taking the adjournment way out of not making the hard decisions and keeping these matters pending. Mr. Singhvi is not the only big legal voice that we have on our show tonight. We've also got now Hari Salve, who's joining us on this show. A quick conversation with Mr. Salve as well. Good evening. Thank you so much, Mr. Salve, for speaking to us here on Mirror Now. Let me begin by where I left off the conversation with Abhishek Manu Singhvi, and that's on the latest controversy regarding the judiciary and the transfer of Justice Muralidharan and the way it's come about at this time. Is it fair to raise questions when the collegium had already recommended his transfer 2 weeks ago?
The problem is this: we, instead of discussing broad issues and discussing the structure of the system, try and pick individual instances. When the National Judicial Appointments Commission was contemplated for appointments and transfer of judges. A lot of people came and criticized them, saying you're taking away this power from the judges and you're putting it in a committee of people. And mind you, there also judges were in the majority. There was just one or two lay people and the law minister who was made a party. When we were also supporting the NGAC, we said it will bring much greater degree of transparency and much greater degree of accountability. That was criticized and said, oh, we must have faith in our judges. If you have faith in our judges and the judges take a decision to transfer one of their own, then to try and pick holes depending on one's own individual assessment of what a judge has done or not done is then putting the court in a very awkward situation. One of the reasons I've always said that the Supreme Court should not have either the power of appointment or the power of transfer is it puts the court in this kind of a situation that its individual decisions are put in question, depending, especially in present times, on in the surcharge atmosphere in which we are living. This creates a huge problem. Now, the judge has been transferred. Justice Muralidhar is one of the finest judges in the Delhi High Court. His integrity, his independence, his intellect, I don't think anything is in question. Why is he being sent to Punjab High Court? I don't know. Is the Punjab High Court a lesser High Court or a better High Court? These kind of comments are hardly called for. It's a very big High Court. It's the High Court of two states. He's being sent there. We don't know why he's being sent. Do you have faith in the Supreme Court exercising this power of transfer? If you do, then you must accept it has been done for the right reason. If you don't have faith in the Supreme Court exercising this power of transfer, then let's think of some other system. But this kind of an individual sitting in judgment by people standing in corridors and gossiping, and this is for good reason, this is for that reason, this undermines institutional integrity, and I don't think this should be done.
No, I completely agree with you, and perhaps it is time to once again relook at the entire appointment system, what we have right now versus the NJSC that was struck down. But Mr. Salve, there is a point being raised about the way the transfer was implemented. In your experience, is this a routine to transfer out a judge like this immediately overnight when he is presiding over such an important case?
I don't know. As you know, Tanvi, I'm not in India. I've not been in India for a while, and I've not kept track of the day-to-day movements beyond reading on your news blurbs and the NDTV news blurbs. My impression is that there was an order of transfer which had already been passed. The Collegium's decision to transfer Justice Muralidhar, I heard about this a while ago.
Yes.
Maybe a month ago or maybe. And the case came up just a day or two earlier. Now, I don't know when this transfer was implemented. I have no idea how it was done. But this is the whole problem. Either we have faith in our system or we don't have faith in us.
Correct.
The other problem I have with this kind of a criticism is underlying this is a assumption that if the case goes from Justice Muralidhar to another judge, the other judge will not have the same commitment to the Constitution and the same courage to deal with the case the way Justice Muralidhar was dealing with. What are we trying to say? See, this is what happens when these kind of cases come before the court, and then the litigants and unfortunately even lawyers start feeling, oh, the judge is making favorable comments at one stage or said something, and then something like this happens. You say, oh, the judge is being transferred for this reason. Is the government? First of all, the government has nothing to do. Look at the sinister implications. The sinister implications are that the government is unhappy with what Justice Muralidhar is doing. And the Supreme Court has quietly and in complete dereliction of all its constitutional duties agreed to play ball with the government and transfer the judge. And that upon his transfer, the case will go to other judges who don't have the degree of judicial. I mean, what are we saying? Do we understand what we are saying? We are criticized. Who can criticize the government till the cows come home? Who can? They are elected governments, they can be criticized. What are you saying about the Supreme Court and what are you saying about the High Court?
Well, I think in this specific case, there are questions being raised against the Collegium and the Supreme Court and the government to say all of this will fall into place to become a larger conspiracy so that one case about filing of FIRs in hate speech cases doesn't go to Justice Muralidharan anymore. But I completely get your point.
And it goes to another judge, and of course that judge has not sworn an oath to protect and preserve the Constitution, and the case will go badly.
Yes.
So we have now criticized the whole Delhi High Court, we've criticized the Supreme Court, we've criticized the whole system that works, all on injunction. And I think this has to stop.
I agree. Mr. Salve, there is another larger issue that we are discussing tonight and putting the spotlight on, and that is the issue of adjournments and adjournments with a longer period of gap and time given in between. Now, Mr. Singhvi, not specifically talking about the case that we were referring to, but wrote a larger article, part of his upcoming book, where he says that courts seem to be deciding hard questions via adjournments. Would you agree that perhaps there have been far too many instances to support that?
Tanvi, let's be very clear. First of all, let's not confuse phraseology. Fixing a case and adjourning a case are two very different things. Adjourning a case is a case which has been fixed for a hearing for a particular date, but for the convenience of someone or the other, or the unavailability of a court is adjourned. The other is a court deciding when it wants to hear a case. Today you have huge pendencies. And because of the pendencies, some certain cases are taken out of turn. Now, it is entirely for a court to decide the importance of a case. People standing in the corridor of the Supreme Court may feel very strongly about the importance of a case. People in public life may feel very strongly about the importance of a case. Judges of the Supreme Court may feel this is a politically significant but constitutionally not so important a matter. We will hear it after we hear some other case. What are the priorities of the cases from the perception of the judges is not necessarily the priority of the cases from the perception in public life. Who's a lawyer. So, this to say that the important cases are being adjourned, only trying to say I would them to hear some other cases, some cases other than what they are hearing. I don't think to suggest, and the underlying suggestion is that the Supreme Court is running away from important cases. I think that's a very unfair comment.
But when a case about filing of an FIR in a hate speech comes up, a 3 weeks adjournment can make a life of a difference to that case.
Why was the adjournment granted? Who granted the adjournment? And sometimes there are cases where the court feels 2 weeks, 3 weeks time may resolve the issue. See, ultimately the case issues such as filing an FIR are peculiar to Indian courts. In no other evolved legal system do such matters even come to a court. Constitutional courts, I have always maintained, constitutional courts are not designed to deal with day-to-day problems of whether an FIR is filed or not filed, or this happens or that happens. Yes, in India, the situation is different. At times, the Constitutional Court has to intervene and make sure that the rule of law is not hostage to politics, or rule of law is not hostage to an inept police. Having said that, just to say that just because one particular case of a particular kind was adjourned by 3 weeks, the court is shying away from its constitutional duties, I think that's an unfair. Our Supreme Court takes on difficult, in the sense, cases which have important consequences, cases which have far-reaching public significance, and decides them fairly and without any fear or favor. So, if a particular judge feels that a particular case should wait for 3 weeks, to suggest that you may disagree with it. Say, no, I'm sorry, I think he should have heard it early. But to suggest that there is something more than that going on, I don't think is fair.
Fair enough. Hari Salve, always a pleasure to have you. And thank you for joining us, all the way from London on this very crucial debate. Appreciate your views. Let's go ahead and open this conversation up to our panel. We now have two big voices telling us sharing two slightly different views. Abhishek Manu Singhvi saying that instead of adjourning it for 3 weeks or 4 weeks, by which time it may actually be too late to decide on certain cases. And in his article, he actually gives the examples about over a case about a forest, and he says, well, by the time, if you adjourn it for 3 weeks, by then the forest may have been chopped down and completely wiped off, and there wouldn't be a point of hearing that case anymore. While he says courts should decide on important issues immediately without pushing them for later, Hari Salve says it really depends on what the case is and who have been made party to it. We can't make a generic comment. What do our other panelists think? That's the big question. Kailash Vastev, senior advocate with the Supreme Court. Mr. A.L. Banerjee, former DGP of Uttar Pradesh. A.S. Ponanna, senior advocate, former additional general of Karnataka State, and Geeta Luthra, also a senior advocate with Supreme Court. And let me actually start with Mr. Ponanna on this one and what he thinks. Mr. Ponanna, let's begin with the fact that today, of course, there was a case a plea that sought filing of an FIR against BJP leaders who've made inflammatory speeches that could have an impact on the kind of violence and hate we are seeing on ground. But the court has decided to adjourn it for a month. Now, would you have rather had a decision either which ways on the plea immediately rather than waiting for another month?
No, insofar as the adjournment that was given by the Delhi High Court, I couldn't have disagreed with it more. It is unthinkable that a constitutional court dealing with an issue as sensitive as the violence that is happening in Delhi would adjourn it by 3 weeks, especially when the previous bench, which unfortunately resulted in the transfer of Justice Muralidhar Rao, was broken, had asked the Delhi government, the Delhi police, to report with respect to the decision they have taken on FIRs. You see, firstly, I don't know how to describe it, the stand of the Solicitor General that it is not a conducive atmosphere to register FIRs goes against the basic tenets of rule of law, goes against the fundamentals of criminal jurisprudence, goes against the judgment of the Honorable Supreme Court, and that such a statement is, in a way, interfering with the dispensation of justice. In the face of it, the division bench of the Delhi High Court directed them to come up with the FIRs that were registered in the morning. And when the bench changes, the court takes a totally different view and adjourns it. So the adjournment is a slap in the face of the rule of law.
Adjournment is a slap in the face of rule of law. Mr. Kailash Vastev, do you agree?
Good evening. These controversies are being raised in a situation which in itself is explosive. We've lost 35 lives, 200 injured, God knows how much damage to property. And add to that a blockade for 70 days. Keep this in the back of your mind. The decisions taken by the court are not necessarily at this point of time based on circumstances which are beyond the control of the executive. The police has been noticing that for the past 70 days, an area of Delhi lies blocked out. There has been violence in that area. There has been additional violence in northeast Delhi, leading to loss of lives over the past few days. What stopped the police from lodging a first information report about these incidents? Why has the police held back its hands in taking actions? What is the motivation of the police in not taking steps to stop this earlier? You have had no violence today, or very little. Why couldn't you stop this before? Now, if there's an executive failure, the judiciary has to step in. It doesn't happen in other countries, it happens only in ours, where all sorts of powers in the public interest domain are handed over to the court. The court then exercises its discretion for two purposes. A, executive action. B, to ensure that the situation doesn't go out of hand. A judge is not permanent in the system is permanent to us. We can have situations where judges disagree in their approaches, but that is the judiciary. That's the democracy in our judicial system. I may have a view as a judge, the other gentleman may have a view as a judge. It is not necessary that we will be at idem, but we can have different views. Here, Justice Muralidhar took a view on the basis of perceptions which were shown to him. The other judge took a view on the basis of information made available to him by the Solicitor General. I'm not commenting right or wrong, but they are perceptions. If we have two diverse views by two judges, can we turn around and say the system has failed us? That's what we're alleging today. One judge would have taken this view, the other judge will not take this view, so the system is bad. Or the other judge is bad. Is that correct? So perceptions in the judicial system are what they are. They have been for years together and they will remain in the future. What is important today and what is the more worrisome element is, we must standardize the practice of transfer of judges. We must look at this policy again. We must rethink as to what can be done to ensure that the independence of the judiciary is not destroyed in circumstances as these, where there is a lot of strife, tension along the roads. Personally speaking, the perceptions will vary and they have got to vary because that is where the substance comes. You have a right of appeal. Justice Muralidhar's views were views available on facts to his knowledge. The views taken by the second bench is also views taken on the information given to them. How can we possibly turn around and say that there are errors because they are both judicial systems? And both are judicial orders passed in different circumstances. The second bench may say because of delay, the situation will work itself out. Dr. Singhvi has a view that this is a situation which needs urgent attention. May I ask one question over here? When has the government not hesitated to play with the judicial system? Go back in time. Think of those days when the first judgment came in 82, SP Gupta, compelling the Supreme Court to look at it in the Advocates and Record case, judicial appointment. 2016, the National Judicial Commission, even that was struck down by the court. So it has always been an intent of government to fiddle with the judicial system. The judicial system tries to protect itself. Yes, they make mistakes. There can be errors. There can be decisions taken on the spur of the moment. That is where the criticism lies. But then can you turn around and say the Supreme Court or the High Court is not discharging its duties? Are we casting aspersions of a nature preventing judges from doing their duties? This is where the whole dichotomy comes in. Being a member of this system, I respect our judges. I respect the fact that there will be a cleavage in opinion. But is that good enough ground to say that the system is not working? That is the question today.
You want to respond to what Kailash Vasudev is saying?
Minus 50. Are you addressing
Yeah, you know,
Mr. Ponnanna, please.
I'm not for
yes.
even a,
Tanvi?
Yes.
Okay.
Yeah. Are you asking? Okay, I'm not even for a minute alleging that the judges, deviated from the set norms. I'm not even alleging that the system is bad. All I am saying is there is a judicial order passed by the earlier bench. So the next bench, which the bench changed because of various circumstances, did have to take into consideration the fact that the earlier bench had shown so much of urgency in dealing with the matter and also had given specific directions. In fact, from what I've read in the newspapers, certain hate speeches or certain speeches made by certain leaders were shown in the open court when the police refused knowledge of these. That is the urgency which an earlier bench had shown. So judicial consistency and propriety would have demanded that they take it in the same lines. Of course, judges are different, judges think differently, different material is available, more material may have been available today before the bench. I agree with all that. But all I'm saying is that the matter that required the kind of urgency that the previous bench showed could not have been adjourned in this fashion for 3 weeks. Now the law is very clear on these aspects. The police must only see if a cognizable offence has been made out or not. If it is made out, they are bound to register the FIR. Now a simple legal position such as this can't be decided on whether it is a conducive atmosphere or not in terms of what the Solicitor General or the lawyer says. So the question before the court was the material available with the police to register the FIRs or not? Where is the question of adjourning a matter of this nature by 3 weeks? So I am only on the order that was passed by the bench today. and not on the judges' conduct. You see, we are nobody to question. Different judges think differently, different judges react differently to different situations, different judges pass different orders. That is the the whole system. That's how it works, and I'm not even pointing fingers at the system. All I'm saying is, kindly look at how the bench dealt with the matter earlier, and kindly see how this bench dealt with it. Irrespective of what is the material was there should have been a specific order today corroborating or in a manner putting an end to the earlier judicial order that was passed. So the court could have said that there is enough material to show that there was no need for an FIR at this moment, or there is no material at all, or there is material, so register the FIR. Some kind of a decisive order should have, more decisive order than merely adjourning this matter, allowing the central government to file the statement of objections as if this is some kind of an adversarial list. This treatment to this particular case, from the limited knowledge that I have on the facts, that is where I am finding fault with the court.
Okay.
I am not finding fault with any of the
individuals
or the system at all.
Correct. All right. I take your point. Mr. A.L. Banerjee, before I go to Geeta Luthra, quick question from, with you. Mr. Banerjee, the police seems to suggest that they are going through the videos and they are looking at the videos of hate speeches and various hate speeches, despite the fact that in Kapil Mishra's case, the judge himself made them watch the video. And they've also submitted in the court that now is not the time for action. We are filing FIRs in the cases of violence, and rightly so. Why would it not be a conducive time to act against those who delivered hate speeches to add fuel to this atmosphere?
Tanvi, let me make it very clear. What I understand from this, and other than the fact that legal luminaries have just talked about this particular thing, the matter came up before the High Court on a PIL, and it said that these 4 or 5 gentlemen had made hate speeches, and the Delhi court, the Delhi police were directed to register an FIR on all these hate speeches. The court made an order asking the Commissioner of Police to go through them and find out if they were sufficiently good enough or they made cognizable offenses or not, and register an FIR if required and come back to the court. When they came back to the court, what transpires is that the government says, or the police says, that it is not a conducive time to file an FIR. They have not given, I have not gone through the whatever petition they filed in the court or whatever they said in the court, but the gist is that it is not a conducive time to file an FIR, and the court has been very kind, or rather, court has given it time for 30 days to then look at it and then file FIRs. Now, the fact is that in the very first instance, much before the PIL had gone to the court, in case earlier on, if the police had been alert, had been clued into this particular thing, had sufficient intelligence input, had input of all other kinds, and had found these to be of the nature of hate speeches, they should have gone ahead and registered it much earlier than today. This matter should have never come up before a court, and a constitutional court at that. So the fact is that people have been lax to figure out whether these speeches amounted to hate speech or not, because they've been around for a long time. For a commissioner of police to say, it's amazing for a commissioner of police to say that he has not gone through any of these hate speeches. It beats comprehension. The commissioner of police is invariably briefed about what has happened throughout the day. Do you think that this photograph that you're showing right now on the screen about Deputy Commissioner of Police standing with a gentleman, or the gentleman saying that after so many days we shall take action, was not reported to the Commissioner of Police? This means there's been a complete lack of communication somewhere. Or for that matter, they've been trying to shove everything under the carpet. Correct. Or for that matter, they find that there has been no hate speech across a period of time. So it is a clear-cut case of police, the Commissioner of Police's failure, and thereby he has put the whole blame on the police system. And again, the judiciary has been called in, or the matter has gone up to the judiciary to decide whether they are hate cases or not and whether they should be registered or not. This is not something that the judiciary should normally be doing. It is a matter which lies very much within the ambit of the police. The police should have found out if they are hate speeches or not much earlier and go ahead and registered it.
Unfortunately, what we've seen is when authorities, from police to government, begin to fail in doing their own jobs, and more and more now these matters are landing up at the judiciary's doorstep because others are failing the citizens of this country. I've got some breaking update coming in that I just want to address right now. An FIR has been registered against the AAP councillor Tahir Hussain. Remember, there are grave allegations being made by eyewitnesses and local residents about AAP councillor Tahir Hussain and his role and his involvement in the violence that Northeast Delhi saw earlier this week. Now, an FIR has been filed for murder of the IB official Ankit Sharma. Remember, Ankit Sharma, an IB official, was murdered and dumped in a drain. Videos of that process of his body being dumped in the drain are available, and BJP leader Kapil Mishra has also gone on to say that it is this man on your screens right now, Tahir Hussain, who's responsible for it. Tahir Hussain, in his own defense, has said that he had left that locality much earlier, that people had surrounded him and his family and his building and begun to attack him, which is why it is the police actually who helped them escape from that entire location, and then his building was perhaps misused as a hub to then further spread out violence. But for now, at least, an FIR has been filed. I'm glad, Geeta Luthra, that at least, in this case, there is an FIR that has been filed and the police is moving ahead to take action. I mean, through this entire process, we've not seen any arrests, any detentions, any preventive, people being taken into preventive custody. I don't know what the Delhi police was doing for those 4 days. Even now, they refuse to move. Does this adjournment help the situation? Wouldn't it have been better if we had a decision, pro or against, either which ways, whichever way the decision went, on the filing of the FIRs today?
So, as people before me may have said, Lalita Kumari has become the law of the land, which basically says that if there is a cognizable offence, then an FIR has to be registered. Now, the question that has been, which seems to, from the arguments which seem to have come up by the 3 people against whom, or 4 people against whom FIRs have been suggested, is that they weren't giving hate speeches. Their speeches, or one of their speeches, was not a hate speech, it was a pro-country speech. So it was saying any terrorist should not live in India, but not that it was against, it was not a hate speech. Now, the fact is that if you listen to these speeches, it will be very clear whether they are in fact hate speeches or they are just pro-national speeches. And accordingly, if they are hate speeches, then clearly an FIR should be registered. Now, of course, we can all surmise what the court should have done or should not have done. I personally feel that if it had been quicker, then the chance of anyone who is not doing a hate speech or who is doing a hate speech but who is being even irresponsible will become much more a sensitive matter. People will think before they speak. I'm not talking about these 3-4 people. I am not talking whether they gave a hate speech or didn't give a hate speech. The law is, if it's a cognizable offence, FIR is to be registered. So the question is that if the court looks at it faster, if the police does not go into slumber, then it's much better, because you will be saving so many people from irresponsible statements, either in media or in social media or in the public domain. And we've been such a peace-loving country. Communities have lived with each other in the most peaceful and loving manner. So we have, each citizen has this duty that they have to be careful of what they say. And therefore, at a time when tempers are high, when people's tempers can easily be ignited, then even a speech which may not be a hate speech, but which may be a speech which will incite somebody, even mildly, should be looked at carefully. We can't be looking at it with, with a completely over legal eye. We have to look at it with a sensitivity that we have citizens in this country, all of whom have lived and loved and coexisted. That's what India is about. And therefore, we have to be careful. And the police owes it. If the police is more careful, then I don't think such a situation will ignite. And it's extremely unfortunate that this is happening. So I would be happier if it had been possibly a shorter date. But I guess I can only say whatever reason, the court must have had its reasons why the state needed the time to file a reply within 3 weeks. But having said that, of course, all of us would have been happier. It's not that the matter would have been closed if it was a week or 5 days or 7 days. Because as we know, in courts, matters go on for a longer time. But just the very fact, if it was quicker or it was earlier, I feel the possibility of other people or anyone making an irresponsible statement would get contained. And I think that itself is an end in itself and is important.
Absolutely, and that's that's exactly what my concern would have been, that if we decide on these issues sooner, firstly, it shouldn't have ended up in the court. The police should have by itself taken action. I don't know what the Delhi police has actually been doing for the last couple of months. And instance after instance has emerged where they seem to have dragged their feet, looked the other way, not wanted to take action. Now it seems they believe that if they take action, it's just going to add fuel to this fire, that this environment isn't conducive. We wouldn't be in this atmosphere, in this environment or situation, if perhaps we had moved earlier to stop it and not waited for 35 lives to be lost. I am running out of time, though, but Mr. Banerjee wanted to make a point. Go ahead, please.
Well, yes, the police in this particular case, in the case of the Delhi riots, has miserably failed, unfortunately. And it's a failure of the leadership. A force is only as good as its leader. In this particular case, the leader has not hit the ground. His boots are not on the ground. He's never been seen around.
Where the national security advisor of the country was forced to step in, get out on the ground and take, go into that locality. Mr. Vasudev?
I agree with what Mr. Banerjee has to say, but I want to add another further point. In the past few months, we have noticed that the police is taking no action on its own. There is a vital need today for all purposes to look into the police functioning. Many police cases are transferred to the CVI, which in itself is a history of a different kind. One is unable to understand that these gentlemen who are in uniform, discharging a duty for the benefit of the public and to protect law and order and to prevent any untoward incidents, are failing to do so. Delhi is not the only place. You will hear of it all over the country today, that the policemen in uniform are not doing what they're supposed to be doing. The consequence is the saddle then transfers from their backs onto the courts. And it is becoming a trend to damn the courts because of the failures of the executive to take action. I think in all debates which you carry out and in all that the press covers, you must also now learn to cover the tremendous failures of policing which are afflicting our system, whether it is our borders, whether it is our internal systems, whether it is a law and order situation, whether investigation of a crime, and what is now getting more disturbing is the elements of corruption coming into the police. FIRs are not lodged. The directions have to be given
Tanvi,
by the courts. The investigation has to be monitored by the courts. I'm sorry, but I'm not able to understand this. Why can't the police do its duty? If they did their duty, we wouldn't have this terrible situation which has come. 35 lost, 200 injured. God knows how many people have lost properties and sources of income. And most importantly, how our people are losing faith in our own system.
Mr. Vasudev, I completely agree with you, and I'll tell you that a lot of
Tanvi, I want to make a quick point.
Who have been on our shows in the recent past will tell you that we've had n number of debates questioning the role of the police, the need for reforms within the police. That perhaps it's also not right to blame the individual soldiers on ground, but the leadership has to be made accountable. In this case, I don't know if the leadership is going to be made accountable. No heads have rolled within the Delhi police. People from outside have been transferred, given charge. The NSA has had to step in. 35 lives have been lost, and no questions are being asked of the Delhi police. How much worse can it get? To that, the Delhi police even refusing to even now file the FIRs is only worsening the matter. I'm just simply going to leave you with this thought without adding any views or comments to it. But this is what Abhishek Manu Singhvi has written. Across a wide panoply of cases, even where it appears that the government has erred, the court has shown a pattern of deferring, adjourning and otherwise leaving the issue aside until it has lost the importance it had. When a court says it will not hear the matter for the next 3 weeks, there is always potential for the forest to be absolutely destroyed before the court even adjudicates this question. He's not speaking about the current case, but perhaps it is also relevant to the case that we saw unfold in the courts today that has now been adjourned for a month. If we don't stop these men from making hate speeches, who will be responsible for what happens on ground as a result of these hate speeches? Thank you for joining us.